once again, I've done my
Michael gets so into listening.
I'm just having my own party here. Sorry. Just me and the judge. Okay.
Plaintiff Abigail's Werner. After you have made your decision unanimously, you're going to check a box. Put an X on the top line or the bottom line. If you put a X on the top line, you will fill in the amount of the award, and then any interest, the date that interest runs from, or an X on the line next to line 2, and your jury person needs.
And the line 2 says, no, she wasn't, the defendant wasn't at fault. But where's the line that says, do you find the plaintiff contributorily negligent? Yes or no? That's it. Because you can't be less than 1% contributorily negligent. And by law in Virginia, if you're even 1%, you get nothing. So they could find that she was contributorily negligent, but it's nowhere on the verdict form. So I think if I'm the defendant and I get that result, I'm appealing that in a heartbeat. And again, you're suggesting if they didn't raise that, they may have a problem bringing it up on appeal.
Well, they have to raise it. They have to object to it, unless it's a constitutional issue. You have to object.
That's what I'm wondering.
If
it's statutory, if there's some other Virginia law that might protect the defense on that front. This guy's been, they also moved for a mistrial today, and we're gonna see why, because I'm going to zoom through some of the parts of the closing. When I heard this, I was shocked. Hey, look, I'm bringing it back on before it started.
and we may be able to hear it. You're so funny when you do that, because you're so into
I know, I'm like watching it.
Whoa, watching it. And
what the hell are you doing? So here, this is the attorney. Let me make sure I pronounce his name, or at least do my best. Young guy. This guy's 33 years old. His name is Kevin Benazian, Benazian. And we're just going to jump into the middle of this, and you'll see some of his visuals. You'll see his style, his passion. I think he does some things amazingly well, especially for a youngster. But I think he goes over the top in some ways.
By direct and circumstantial evidence. What does that mean? I don't need to see the rain coming down from the sky to know it's raining if I walk out in the morning and there are puddles on the floor, right? I don't need to see the rain. I know it rained.
Classic law school.
And when Dr. Parker says, in response to, did you search the person? We checked the bag. What that tells us is that was a real threat. That it was accepted as true, so much so that we needed to check the bag. All this talk about we didn't think it was a real threat. It wasn't a credible threat. Why are you agreeing with Ms. Kovac to search the bag if you don't think it's real? And when they say, did you search the person? And the response is, we already checked the bag. Guess what that tells us? We thought it was real, and we don't know where it is anymore. We don't know where it is anymore. And then the boy outside of Miss West's classroom crying, remember? Crying, not wanting to go back into Mrs. Z's classroom where he's supposed to be. Says bullets and shoot. The boy showed me bullets. JT showed me bullets. And he said, if I told anybody, I would shoot. Bullets, shoot, gun. The only way you can shoot a bullet is if you have a gun. And to tell us that telling a boy that he will be shot is not a threat, not a threat, goes against the very language that 6-year-old used. And then he goes and has a conversation with her again. You heard from Miss West, who said he was crying scared. I talked about R a moment ago. He was crying scared. And I suspect what you're going to hear from the other side is, well, we didn't get good information. Remember that from Dr. Klinger? Well, we didn't get good information. We didn't know that he was crying and scared. Somebody should have told Dr. Parker that he was crying and scared. When we go out onto the road,
Here we go.
and there's a stop sign on the corner of the street, tuck it behind a little corner or right there for us to see either way. It's our job as we're driving down the road to see the stop sign. It's our job to look out for the stop sign. It's our job to find the rules of the road and the signs of the road so that we can then govern our behavior. It was Dr. Parker's job to investigate. The manual that governed their relationships amongst each other told her that you must first assume it is credible unless analysis suggests differently. Cause the student making the threat, if known and on campus, to be immediately removed, pending further investigation. What does that mean? That means you can't stick your head in the sand. You cannot stick your head in the sand and then come into court and say, I didn't have the information when it was your job to find it, when it was your job to look for it and to do the investigation and to talk to that little boy who saw the gun and to talk to those two little girls who talked about the gun and to talk to all of these people. If it's your job to investigate, which their handbook tells them it was, you can't come into court and say, I'm going to close my ears, close my eyes, put my head on my desk, and then use that as a defense to my case. The law says you know it because it was there to be known, because the stop sign was on the corner of the street and it should have been seen. It's no excuse to walk into court on a traffic ticket and say, well, Judge, I didn't see the stop sign. The stop sign was there. The stop sign was there, feet, yards from her. And then, in my view, you turn up the dial. Because at this point in the afternoon, there is a accumulation of information. We saw a gun. It was supposed to be in a backpack. We don't know where it is. It might be in his pocket. It was shown to a boy at recess with bullets. We still don't know where it is. He's crying, won't go to class. And another request. Can we search the person? And I suspect they'll come up here and they'll say, well, Mr. Rawls told you that he didn't think it was credible. My response to that is let's look at actions, because our actions speak louder than our words. Did we hear any other evidence of Mr. Rawls coming and asking to search just kids at random when he didn't think there was a threat? We talked, and all of the evidence is that searching, and even Dr. Klinger told us, searching a child is something that you do delicately. You only do if it's necessary. That's what they're taught. And he came to her directly and said, have we searched the boy? Again. And he wasn't the only one in that moment. Because in that moment, when she heard, West heard, that they had not searched the person, Mr. Sims goes and stands outside the door of Mr. Rawls and Dr. Parker and says, are we searching the person? That's 3 times somebody is asking her to do this. 3 times. Countless times where we're talking about the boy throughout the day and a gun and where it is, but 3 times to search the boy. That should be flashing at you to act.
Okay, so let me get your thoughts on this before we move on to a little bit more of his
I really like his style. It's not
He
my
didn't. I didn't see him look at a
style,
note once.
but it's not that. All of a sudden I was engrossed. I wanted to hear what he was saying next, and I started thinking as a lawyer, of course, and thinking to myself, well, what is a stop sign? That there was
Yeah.
the weeds weren't cut down because the county never cut the trees growing. And we have to search it out. But I really liked him. I really
Some of
thought
his
it was
visuals
terrific.
were a bit much for me. The head in the sand, and some of those very literal. Okay. I think he was able to use his PowerPoint really as his notes because
Right.
he had it so down that each of those slides triggered whatever he was talking about next. Very personable, very connected to the jury. You could just tell. He got, like I said, I felt he went over the top a couple of times into the cheesy category, but overall, especially for somebody relatively young, I was impressed. And it's funny, when I watch some of the pretrial activity, maybe it's my biases, but I can tell a plaintiff attorney from a defense attorney. Just this guy is just a little slicker. The defense guy was
Oh,
no,
come on.
the defense guy was good mechanically. He was there, just not quite as slick.
Well, wait a second. What you're meaning saying slick, what you mean is that he is connecting with the jury. He
And
is
I mean polished.
he's polished. But yeah, polish is, but slick sounds like, you're the ambulance chaser.
No,
Polish is
I
good.
wouldn't. I
He's
wouldn't look at it
polished, okay?
derogatory. I think he's
Yeah.
he's slick. The guy, he's smooth.